to the second last business law workshop, special edition, the field students. Today we have two presentations, one by Catherine Morby and the next by Jonathan Chan. We are having some trouble allowing you to switch on your video. That I hope Agatha will be able to solve, because I have no clue, frankly. And we are going to record, actually we are already recording this seminar, so that you are aware. And the usual rules apply. The only difference is that today the speakers will have 20 minutes and then we'll leave 25 minutes for Q&A. So without further ado, Catherine, the floor is yours. You have already shared the screen, so I think everyone is able to at least see Catherine's slide.
Okay, thank you very much, Luca. I'll share my video the moment I get permission to do so. First of all, thanks very much for giving us an opportunity to speak. What I'll present today is part of my DPhil thesis on the corporate governance of non-bank systemically important financial institutions. So questions, comments are more than welcome. The main problem I'm tackling or trying to tackle in my DPhil thesis is the idea that certain types of financial institutions, banks, but also non-bank financial institutions, can present systemic risk. Basically, their activities can contribute to instability in our financial system. And sort of my research question is, to what extent the use of corporate governance regulation can be useful to gain traction to mitigate systemic risk presented by these institutions. What I mean by corporate governance regulation is basically the regulation of the internal decision-making processes of a corporation. Typically, a lot of debate has been about bank executive compensation, for example, board structure, etc. And how do I tackle this today? I'll basically talk about one type of non-bank systemically important financial institution where I think corporate governance regulation is a useful mechanism to help gain traction to mitigate systemic risk. And more specifically, I'll talk about a corporate bond index fund. Okay, what is the starting point of my analysis? The idea is that Prudential framework at the moment mainly relies on two building blocks. On the one hand, it starts from prudential norms, so basically regulation that determines the types of behavior it wants to encourage from systemically important institutions and the type of behavior it wants to discourage. For example, banks are required to get a certain amount of capital on their balance sheets. Banks aren't allowed to engage in certain types of proprietary trading. So these are sort of norms that regulate the content of the decisions that are being made by systemically important financial institutions. As a general, in the FinReg literature, it's accepted that it's impossible to ex ante determine all the actions that these institutions can take. So by its very nature, these norms, these prudential norms, are going to be incomplete. Financial markets are high-paced, they're complex, they're changing constantly. So we need some sort of gap filler to sort of adjust norms as we go along. And the sort of standard legal strategy in the FinReg literature is supervision. So supervisors, and that's sort of the second building block, supervisors are seen as gap fillers to sort of fill up the incompleteness of prudential norms. And they do that via, in theory at least, continuous interaction with the systemically important institutions, so they can follow up the risks that are involved and they can take appropriate measures. my argument in my thesis and my research project is that there's quite some use in having a third building block to sort of complement the first two. And that's a block of governance regulation. So regulation of the way financial institutions take decisions. In banks, that's something that is already quite established, and there's a vast amount of literature that argues that it's a good complement to regulate governance in banks. Again, typical the whole debate about bank regulation of compensation. Executive compensation is a typical example. Because the reasoning behind these types of interventions is that supervision is also not perfect. For example, supervisors might not necessarily have all the information that is necessary to take the right actions. So governance regulation can sort of complement there. Banks are, of course, not the only systemically important financial institutions, and other institutions might actually also benefit from this third building block in a prudential framework. And today I want to talk about one type of systemically important institution, and that is an example out of the asset management industry. It's a corporate bond index fund. And the reason that that could potentially be a systemically important institution is sort of relies on three pillars or three steps in an analysis. First of all, what is a corporate bond index fund? It's basically a bond that typically allows for daily redemption of the shares of those investors. So investors have the right to, at a daily basis or at least frequent basis, go back to the funds and get the net asset value of the investment of the funds in exchange for their share. And then what is an investment strategy of this fund? It's basically to invest in bonds that are included in an index. For example, the S&P investment grade corporate bond index. Why do I think this has a potential to be systemically relevant? First thing is the fact that we have daily redemption rights of investors. So investors can go back to the fund and ask for their percentage of the net asset value. Doesn't really rhyme well with the fact that corporate bond market isn't as liquid as we want it to be. There's actually quite a lot of debate about the illiquidity of the corporate bond market. And that sort of resembles very much the problems that we see with banks, where we have liquid deposits funding illiquid loans. So that sort of is a first red flag that we see in these types of institutions. The second thing is that this illiquidity, this liquidity mismatch between daily redemption and illiquid corporate bonds can create first movers advantages of investors. If investors are worried that there might be issues, troubles at the fund, they might have incentives to be the first one to redeem, because they know if everybody redeems, the illiquidity of the corporate bond market will ensure that last people paid won't get paid. So it's better to be first in line before the corporate bonds are being sold at discount prices, and not everybody will be getting paid. So these first mover advantages can create a run on a fund. Such are we concerned about a run on a corporate bond index fund? Not really, unless it becomes a systemic run, unless it's a run that has an impact on the financial system to such an extent that it actually affects the real economy. Could that be the case with the corporate bond index fund? In certain scenarios, it could be. Imagine, for example, if it's just one bond index fund that has issues, it's unlikely to impact market prices. But imagine that, for example, there has been an announcement by the Bank of England that there'll be an increase in interest rates. We have had an environment of low interest rates for a long time, so they might feed fears that has come to an end, and there might be an increase in interest rates. People run on the fund, and not only on one fund, but on basically there's a correlated run on different corporate bond funds. In that case, there might actually be an impact on the corporate bond market itself. And if we have a closure or issues at the corporate bond market, that might actually create spillovers to the real economy through the funding funding channel, because if certain companies rely on the corporate bond market to fund their activities, a closure of that market might make it more difficult to fund new investments, to pay employees, etc., create rollover effects to the real economy. So bottom line is that there are scenarios, and that sort of takeaway from this slide is that there are scenarios where this type of fund could present systemic risk. So therefore, we are interested in their prudential regulation, and as a consequence, and to what extent corporate governance regulation can be a useful third pillar or a third building block for that prudential framework. So what is the current prudential framework that is in place of this type of institutions? So when we look at our first building block, the prudential norms, we'll have to look at the UCITS directive. This is basically the directive in the European Union that regulates these type of funds that offer daily liquidity for investment in corporate bonds. The way they deal with a possible liquidity match of very easy redemption terms, very frequent redemption terms, and possible illiquid investment is through a very sort of stringent investment policy regime. What is the investment policy regime in the UCITS directive? Basically, it allows UCITS only to invest in presumably liquid assets. So basically, if you offer frequent redemption rights to your investors, you have to invest in liquid investments to ensure that there's no liquidity mismatch. However, what is a liquid asset? And that's obviously the $1 question here. And the regulator has been sort of receptive to that, and the rules determine this. It's not an exhaustive list, so there's a few examples of shares on listed exchange, bonds, etc. But then there's also a set of criteria where there is some sort of open-endedness to fill in what types of institutions might be considered liquid, and there's a few criteria to determine that. So the main takeaway is that the prudential norms in UCITS that would govern our systemic risk problem we talked about the previous slide is incomplete. There's an open-ended norms that the exact content of it need to be determined ex post. And that's also normal. I mean, it's impossible to have an exhaustive list of all types of investments that are liquid, because liquidity is something that changes over time and that might be subject to financial innovation, new instruments being adopted. So bottom line, our prudential norms are incomplete. The standard legal strategy then is to, from the FinReg literature and from our prudential framework, traditional prudential framework, is that the supervisor will fill in those gaps by those norms. And the question is, to what extent is that a fulfilling and complete solution to our problem? And there's basically sort of three variables that I identified that could determine whether that is a complete solution. And in doing so, that also carve out a potential role for governance regulation by laying bare certain flaws that we see in our supervisory system. And the first thing is the supervisory competition regarding prudential requirements. How is supervision organized under the UCITS directive? Basically, the national competent authorities remain responsible for the supervision of the funds. So in the UK, that would be the FCA. So there is some sort of national competence there. ESMA will have some sort of competences for ensuring convergence amongst the different national supervisor, but as a general rule, it's done on a national basis. And that sort of opens questions about arbitrage. UCITS has, regarding regulatory competition, sort of harmonized a lot of the regulation, or a lot of prudential norms available, or so-called first building block. But the fact that supervision is organized at the national level could that potentially result in supervisory arbitrage, where companies start shopping around for the most attractive supervisory system. Supervisors might then also want to attract companies if, for example, they want to increase their tax income, and that might make them more lenient that they should be from a systemic risk perspective. So that's a sort of first problem that we see where governance can provide an answer. For example, if you sort of make managers less sensitive to profit maximization for their company, they might be less inclined to shop around for the best supervisory system. The second sort of variable that is interesting to look at to see flaws for prudential regulation is the nature of supervision. As it is now, we've sort of talked about supervision as this very flexible process that sort of manages monitors the financial institution on a regular basis, very much like it is for banks. However, that is not necessarily the case, and especially in the asset management industry, if the FCA considers a fund as low risk, it's likely not going to be visited for a few years. So we definitely don't have this very flexible, continuous interaction between the regulated entity and the supervisor. So if we're talking about open-ended norms, that can be a problem because that leaves a lot of discretion to the regulated actors to exercise that discretion. And then the third sort of variable that could carve out a role for governance regulation, or at least informs to what extent we should use governance regulation, is who possesses information. And in general matter, there's often information asymmetry between the supervisors and the regulated entity. They might have more information about what actions are about the risks that certain activities pose, about the portfolio and their investment strategies, for example, in funds. Flip side, sometimes the supervisor has more information. If we talked, for example, about the liquidity of the corporate bond market, the supervisors might actually have more information about that. ESMA actually launched 2 years ago now sort of assessment of the liquidity of the corporate bond market under its competences on the MiFID rules. So they might actually be in a better position than individual funds or asset managers to assess these issues. Sort of these three variables related to the characteristics of supervision carve out a role for governance regulation. Why? So for example, if we tie this back to our corporate bond funds, supervisory competition can potentially be a problem because it's organized at the national level. The nature of supervision isn't very strong. It's very likely that they're not as heavily supervised as, for example, in banks. The locus of information, in that scenario, actually supervisors might have better information about the systemic issues that are present in the fund because they might have a more macro perspective on the liquidity of the bond market more generally. Okay, so given our sort of assessment of the two more traditional building blocks of prudential regulation, the question is, can a third building block be useful here? And for governance regulation to be useful, it's good to determine whether actually managers are given in the private governance arrangements perverse incentives to increase systemic risk. Like we saw the whole debate about bank compensation after the financial crisis, where it was argued that managers had incentives to excessively engage in risk taking. And when we talk about our example fund, the UK Corporate Bond Index Fund, how are they being constrained? The main thing is that they just have a very limited investment mandate. They can only invest in corporate bonds that are listed in a certain index. The way they're compensated is they're compensated by a percentage of the assets under management. And that sort of governance setup in good times is unlikely to give a lot of problems from a systemic risk perspective. The reason for that is that there's just not a lot of scope for managers to adjust their strategy to increase their compensation. They're very much tied to investing in a certain type of corporate bond that is listed in the index. The problem, and that also sort of ties back to the type of systemic problems that these funds can present, the problem is more in how they manage liquidity in case there is a liquidity problem. And if there's a lot of withdrawals from the funds, how do they manage that? Because you can manage the impact on the market prices if you properly manage your liquidity at that time. And there are a lot of tools available. For example, you could suspend redemptions on your fund, basically prohibit investors for a certain amount of time to suspend that fund, suspend their redemption rights. The problem is managers of such funds do not necessarily have the right incentives to decide on how to apply these types of mechanisms, such as suspension of redemption. Why is that? Their reputation might be on the line. If they are suspending their funds, people might sort of think that they haven't properly managed the liquidity. They might be worried that there's spillover effects of funds, of other funds of them that might not necessarily are in trouble, but that carry the same brand. And third, it might be that managers have to act in the interest of the investors. And it might be that even though suspension would be good for systemic risks, that's not necessarily the case for investors. It might be, for example, better for investors to not suspend, so that allows them to withdraw from the funds before everything goes bad. So bottom line is, managers and the way they are restrained is not the best they don't have the best incentives to decide on these liquidity management tools. So what would be the governance solution? Governance solution would be to actually transfer the responsibility of these decisions to supervisory authorities. And the good thing is that in the UCITS directive, this is actually already in line with what is foreseen, because in the UCITS directive, you can allow prudential authorities to suspend redemptions in case of public interest. What public interest is, there is no sort of harmonized definition of it, but systemic risk could be part of it. Then the question is, why don't we just solve this via a hard and fast rule, where we basically say if the fund drops, the fund liquidity drops under a certain percentage, they need to suspend the fund. And in the US, for example, for money market funds, that was a recent addition to the regulatory framework, where for money market funds, if the liquidity drops below 10%, a redemption fee is imposed almost automatically. Why is this not as good? First of all, by its nature, that is micro-prudential. It only considers sort of the liquidity in the fund and doesn't consider the sort of macro elements to that. And the second thing is, it might actually entice a run. Having such a clear rule might entice people or investors when they see, oh, we're approaching this 10%, might actually entice a run, and it can be pro-cyclical in that sense. That's why sort of a discretionary decision is more important, and by sort of transferring that and basically giving the Prudential Authority sort of governance intervention right, or sort of an intervention right in the governance of these institutions for that decision making could be useful. Obviously, we've talked about supervisory competition and arbitrage being a problem. This is obviously not solved because we're working with supervisors that work on the national level, and that's why ESMA supervisory conversion powers might be quite important. For one thing, to have a definition of what public interest is and make clear that having these redemption tools, suspension of redemption as a tool for systemic risk, and establish that. I mean, there are also proposals to have ESMA directly supervise the asset management industry, and that would, of course, even be a better scenario for the reduction of supervisory arbitrage. But as such, I think it would go a long way if there's supervisory convergence. And recently, a few months ago, ESMA has launched an action to, specifically for the liquidity of UCITS funds, has launched an action for a convergence of practices where there'll be an evaluation of how things are done at the different member states level. Okay, so basically the conclusion is that where traditionally a prudential framework relies most on our first two building blocks, prudential norms and supervision, I think a third building block is quite a useful way of complementing that regime. A lot of it has been set in banks, but there are other institutions out there, and I've given an example today of UK corporate bond index funds, where this could actually be a useful thing, and it might be good to think through as a sort of addition to our prudential framework. Okay, that's it. I'm open for questions.
Thank you, Catherine, for the excellent presentation. It's now time for everyone to jump in and ask questions. You can do that as usual. Oh, I see. Yeah. Christine has some questions, so I will ask her first.
Thanks so much, Katrin, for your presentation. I really enjoyed it. I'm jumping in first because I have to go and teach in a minute. So let me just stream off the questions that occurred to me while I was listening to your really interesting presentation. First question about the basic taxonomy. What you describe as prudential norms is rules, right? I mean, they may also be described as norms, but you're basically describing rules imposed by the regulator.
Yeah.
And then supervision is what you described as filling gaps between the rules on a more ad hoc basis, which is something less than a rule. And then governance regulation, I think you said that's about regulating the internal decision-making by a fund in your example, or by a firm. But it seems to me the solution, well, there are two comments I had. One is, aren't prudential norms kind of premised on governance and the failings of governance? So is it right to see these as separate? And then secondly, the solution you describe, is that really a kind of governance solution? Because what you're really describing is just that I think, if I understand correctly in your case study, that the regulator just prohibits redemption for a period of time.
Yeah.
So, I mean, I can see how, I guess we could characterize this as governance in that you are making the decision that you say that managers are insufficiently incentivized to make for themselves under some conditions. But that's as far as it goes for me, I think, in terms of seeing this as a governance strategy, unless we can see that I suppose the next stage in the analysis would be by threatening this as a credible prospect, maybe then you will change how managers conduct their affairs in the shadow of the threat. So just, I guess, wanted to understand how you see this impacting beyond the immediate effect of imposing the suspension on redemption. And then on that suspension of redemption, I wanted to ask, does this really involve a transfer of control? It doesn't, I'm not sure there is any transfer of control rights, except to the limited extent that the managers are deprived of their ability to authorize redemptions. And then my final question is, if players in this market are exposed to more than one fund, then why don't they bargain for this protection themselves? Because I can see your point that it's a systemic problem, it's a macro problem, not a micro problem. But players are presumably interested in that problem ex ante to the extent they are exposed to more than one fund. So are they in practice exposed to more than one fund? And if they are, then why aren't they worrying about this in terms of constructing the way in which redemption operates? Because if they were worried about it and bargaining for it, then we might be less worried about the fact that regulators haven't imposed this resolution tool to date. Sorry for so many questions at once. But that is the end of them. Thank you very much for your presentation.
Thanks a lot, Kristen. I appreciate it. I mean, so maybe on your last question first, before it slips my mind. I mean, I guess I don't know exactly. They're not necessarily exposed to multiple funds, but it's just that there might be the problem. The systemic problem lies more in the idea that there will be a lot of sell-off in the market, which could close the corporate fund market, which could then spill over via funding markets. The exposure, and maybe I've misunderstood the question, but I think the exposure as such, it doesn't matter whether investors are exposed to different funds. It's more that if a lot of people herd in the same types of behavior, that could be problematic. And that could be the case if, for example, there is a fear that interest rates might start rising again. And that might be a reason to all herd out of funds. And maybe I haven't stressed it enough in the presentation, but with index funds, that can be particularly problematic because there's not a lot of discretion of what corporate bonds to sell. They basically buy and sell whatever is in the index, which sort of increases this herding behavior, this selling behavior, which makes it a lot more systemic because we don't want them to dump similar funds at the same time, because that can depress prices. So then the first question on sort of taxonomy, I agree, it's probably whether it's governance or not is sort of depends a little bit on the definition of it, I think. And I think there's definitely definitions that are a lot less all-encompassing as I see governance. But what I see as governance is basically everything that sort of constrains the decision-making of managers. Prudential rules I see as everything that constrains financial institutions from doing certain things or encourages us to do certain things, take certain content-wise decisions relating to their activities. While I think in this scenario, this is for me is a governance interventions, because it's actually not that much different than when you would say that the government has a seat on the board of directors and they have a veto right. And in that case, nobody would doubt that as a governance intervention, because in that scenario, it's about the composition of the board of directors. Here, I mean, you could design it at that. I mean, Omarova has a paper where she actually advocates for that in banks, where the government has a seat on the board of directors with very little rights in good times, and in bad times they have a lot of veto rights. A structure like that, where there could be intervention from the prudential authorities in certain types of decision, is actually not that much different from that. So that's why, for me, this is governance regulation. It's not certain rules, it's just a certain decision that's being taken or vetoed or imposed in that sense. So yeah, I think maybe that also is a little bit the second question you had. It is all about this sort of discrete decision on redemptions, and if that is systemic, that then can basically decision can be made that is in line with systemic risk, and that's a little bit the idea. So yeah, it's transfer of control. Maybe it is a bit of a sort of, maybe it's a bit overbearing as a, I think I would agree actually that it's maybe a bit overbearing. That's not a transfer of control, but rather a sort of discrete intervention. So yeah, that's probably a better phrasing, not to call it transfer of control as much. Maybe more transfer of responsibility of a certain decision rather. I don't know if that addressed all of your questions.
It absolutely does. Thank you very much.
Okay, thank you.
Okay, I have a follow-up question from John, and then a question from Geneviève.
Hi, Katrin. That was really interesting. Thanks. Just to follow up on Kristen's question about sort of the taxonomy nomenclature, I think I understand more clearly now that you've sort of define what you mean by governance, and you use norms, and specifically prudential norms, throughout. And I wonder why you do that as opposed to talking about standards or rules. And I know you engage in the rules versus principles debate in the paper, so it's clear that it was you've thought about this. Because when I think of norms, I think to some degree they're all open-ended or incomplete to some extent, but I know you distinguish between incomplete versus complete and open-ended versus non. So I thought maybe just any insight you had there.
And I think I agree that when we're talking about the first building block to stay within the taxonomy, probably all norms are going to be incomplete. I think the sort of question is to what extent supervisors can be complete enough to fill them. To fill in that completeness. And so then if you're talking about rules, standards, debate, the question is whether with rules you think that, okay, at the level of the first block, there's a completeness and there's just need for compliance and enforcement or whatever by the supervisors. There's not a lot of discretion left. With standards, if you think supervision can be complete as a solution, you would assume that the supervisor can be satisfactory in solving potential loose ends, basically, of those norms.
Okay, let me remind the attendees that they can use both the chat and the Q&A to ask questions. Geneviève?
Yes, thank you. And thank you, Catherine, for your presentation. Very interesting and so provoking. I love the fact that you refer to the paper by Katerina Pista and Xu, which I think it's a very, very interesting paper, and it's not quoted that often. And when reading your paper and listening to you, I was wondering to what extent what you call governance, so going back to this word, you were actually telling us about building cultural infrastructure around legal frameworks. And I thought it was actually very wise of you not to mention the word culture, because as soon as you say culture, people start pointing pistols upon us. But I wonder whether it's still, it's however in the background. But perhaps you can tell me whether I'm correct or not on that matter. And the reason I'm saying this is when you say, it's about constraining decision making of managers, but the way managers make their decisions, of course, is infused by their culture. And this leads me to my second question, which is, so I think if I understand you correctly, you are suggesting governance rules at the EU level, right? And I'm wondering whether you, and perhaps it's something, it's in the paper and I didn't say it, whether you're also considering such change in governance at the level of the funds themselves or the firms, at a more sort of at a more micro level. Because if cultures, if we're talking about culture, it's more micro, perhaps micro issues, more difficult to sort of tackle. It's more difficult to get grasp on at a higher level. And if you have this in mind, then we can, because this is my third question, and sorry for the string of questions, then we can start also thinking about what would it mean in practice? Because I was thinking, but how are you going to, get this done? What are going to be the concrete suggestions? And I can see ideas at the more sort of at a more micro level, but could also be generalized. So I was thinking of modeling perhaps the type of conflicts that you mentioned that some, but modeling them and perhaps passing them through people, managers, to see how they react in order to have them self-reflect on their behavior, etc. So this was one idea I got listening to you. Another one would be so you're in a way we're also talking about standards in the industry. So perhaps one sort of one entity could try and promote a pioneer into standards and then get the benefit of it. Like it's sort of a market. There is a sort of a marketing benefit from it. Or perhaps sort of ideas about personal liability and sort of clawbacks and this along these lines.
Yeah.
But yes, I would be interested in hearing thoughts about sort of concrete ideas if you have any.
Okay, thank you very much, Genevieve. I appreciate that. First, the relationship between culture. I mean, culture is very difficult to regulate, and I'm sort of convinced that sort of more hard governance interventions, like we see it, like compensation, can drive culture as well. So I think I find it difficult to sort of talk about them separately, because the way.
But are you tiptoeing around culture, and are you not mentioning it on purpose, or actually in other chapters you mention it?
So I don't, and I think it's also a bit sort of, I think, depending on the governance issues. So how I tackle this is, what are the sort of main constraints that we see in these institutions? For example, in index funds, it's mainly because they have a very limited investment constraints, and that sort of aligns their interested investors. Investors know what they're getting the bonds and the index, and that sort of mitigates potential agency problems between the two. So I'm looking at these and to what extent they create perverse incentives, and therefore whether changing them could actually help us solve part of the puzzle of how to address systemic risk. That said, I think, and that is, I think that's also a useful way of looking at it, is that you could look specifically at culture as a potential constraint and see how it impacts the behavior of managers and how it affects systemic risk. And I think that is a very similar analysis, and I could probably do the analysis of how the culture is in a certain company and what it affects it, and what sort of is the sort of triggers for having a certain type of culture. But I think that is sort of outside of the scope of what I'm trying to do. I'm basically more giving a sort of a suggestion of problems that you could have, but obviously people are constrained in a variety of different ways, and there's psychology literature involved as well, and so I'm not dealing with all the different types of constraints, but I agree that it is potentially something that could impact as well in the way they're making decisions. So as a result, also in the way that they take decisions relating to systemic risk. Then it's true, like I think governance by its very nature is often micro, and so a lot of things you suggest, I mean, bank compensation, for example, is macro, but for example, transferring control or responsibility better to Prudential supervisor is actually more of a taking more of a macro perspective as well. So I don't want to see governments. I mean, governance, the analysis of governance will be in nature micro, because you're looking at decision making within an institution. But the solutions can be more system wide as well, and it sort of is exemplified, I think, with today's solution I offer. And then regarding sort of concrete suggestions and standards in the industry, produce suggestions that will depend on the case study. I think here, I think with this type of systemic risk that you see with index funds, a suggestion, just because it is very much a problem of correlated sales, you need something system-wide, you need Prudential supervisors to be able to intervene. If in another case, for example, in hedge funds, the problem, for example, long-term capital management problem was more about a lot of leverage. That is more something that is internal to the firm. So then practical suggestions would relate more to what is their compensation. It's very much like we talk about in banks, right? In systemically important banks, a lot of it about the compensation. So if a problem is similar to that, you can also have a similar solution. And then standards in industry, I think last sort of comment, first of all, if when related to externalities, industry doesn't necessarily have, from a profit maximizing perspective, incentives to have correct standards. I understand the sort of marketing aspect of it, And we see it with sort of the whole asset management industry, where ESG has become this magic word of attracting funds, while it's not really clear, well, actually these things are very sustainable. So I can see that maybe from a marketing perspective, they want to adopt certain standards. The question is whether that would result in standards that are in line with our Prudential goals, and that is then to be determined.
Okay, thank you, Catherine. We have to move on. Unfortunately, there were other questions from Tom and from me, but we will write to you separately. And so, John, the floor is yours. I know you have slides to share.
Great. Just give me one moment to set up the slides.
Yeah. We see them.
Great, lovely. Oops. Sorry, 1 second. I'm just having a little issue over here. Thank you so much, everyone, for joining. And thank you, Luca, for the opportunity. Today, I'll be presenting on how do legal rules evolve, and specifically, how do rules on stock exchanges evolve. And to begin with some background, this paper forms part of a chapter in my thesis, which focuses on AIM, which stands for the Alternative Investment Market. AIM is a smaller stock exchange. It's owned and operated by the London Stock Exchange. There are about 1,000 issuers on it, and it's intended for small and medium-sized enterprises. It's self-regulatory in the sense that the London Stock Exchange writes and enforces the listing rules on AIM, unlike the main market, where the FCA writes and enforces the listing rules. And on AIM, what's quite unique to the model is that every company needs to have a nominated advisor, or a nomad. And a nomad is essentially a corporate finance firm that advises the AIM company on the listing rules at all times. The nomad is liable to the extent that the AIM listed company violates the rules. The nomad may be penalized as well. And so here, what I've done is quantify changes to the AIM rules over time. I'll explain the data set in a moment, but the motivating inquiry really is, how do legal rules evolve? What might cause rules to be revised? And the specific question is, how have they evolved on AIM, and why might they have evolved this way on AIM? And this is important because around the world, even in government-led stock exchange models whereby the central government plays a significant role, all stock exchanges have some degree of self-regulatory authority. Typically, at a minimum, you'd see this over listing eligibility requirements, trading rules, often continuing disclosure rules. AIM happens to be quite a good example of an exchange with high self-regulatory authority. But the question is important because globally, governments need to delegate some degree of authority to market institutions, and we want to understand better how much authority should be delegated. To answer the question, what I find is that on AIM, the rules are revised sporadically rather than in a consistent piecemeal fashion. So what you see is high peaks of regulatory rule revision activity, followed by troughs of stasis where there's relative calm. Now, I propose that rule revisions are triggered in response to reputational threats to the exchange. I'll develop this thesis in a moment. And step back and just think, well, what are the broader contributions of this study? First of all, it's nice to have some information empirically about how rules are evolving on AIM. So it's nice to know from a policymaker's perspective, the first half of AIM, we see more than 3/4 of the revisions. What might that mean for other self-regulatory environments? what does that mean for path dependency and the ability of rules to evolve over time? The second thing is that this tests a theory of why rules evolve. The theory can obviously be applied to any data set, and hopefully will provide future sources of collaboration and inquiry. And the third contribution is that it adapts an existing lexiometric methodology to account for rule revisions over time. And just to clarify what I mean by this is that most lexiometric studies will look at all of the rules in a system over time and will code them. And then they do that at every single year or a consistent time interval to create an index. So if you're looking at investor protection, you might find an index. I'm not doing that. What I'm doing is I'm looking at when the rule evolved, at what specific date, what specific time, what type of rule evolved, and what was the nature of the revision, as opposed to the nature of the rule itself. So it's a different methodology, and it's to try to understand how rules evolve over time. Now, to conduct this study, I need to first create a data set. And so AIM was founded in 1995. What I've done is I've chosen the rules, which required obtaining some hard copies. I've then read them to develop some themes about how might I think rules evolve, what categories, what do I think is driving rule change. I then needed to develop a coding criteria. So how am I going to categorize observations about the rules? And then I needed to go back and code the rules to create the data set. Now let's jump in, and we'll jump in with the data, and I will try to explain the theory as we go here. If you can all see this slide on the main 5 peaks of rule revision activity on AIM. What this shows, so the orange shows major revisions. I classify all rule revisions into major and minor. The blue are minor. Really what's most important to focus on are major revisions here. And I show that when we look at rulemaking activity, we see 5 peaks. Now, what could explain these 5 peaks? Well, I suggest that in self-regulatory environments, rule revisions are triggers to threats to a regulator's critical goal. Now, this critical goal could differ from a regulator to regulator. It may be a publicly espoused goal, like investor protection. It may be a privately held view, such as profit maximization. In the case of AIM, I'm suggesting that the exchange is motivated by reputational threats. Now, why might this be? Well, AIM occupies a very small amount of the London Stock Exchange Group's balance sheet. However, because the LSE is associated with AIM as a brand and the LSE regulates AIM, there are reputational externalities. So when harm, for example, when there's a scandal on AIM, the LSE itself will bear a portion of that reputational externality, and so is motivated beyond just the extent of which AIM is bringing in revenue to protect its own reputation. And so here I've found 5 peaks of rulemaking activity. Now, the first peak is in 2002, and I suggest in the paper that this was because at the time, the number of companies, issuers, had doubled on AIM in the preceding 3 years. So if we jump on to this next slide, here what we see is the red line is showing the number of listed companies on AIM over time, and we see a precipitous increase from 1998 to 2002. I suggest that this was a result of the tech boom, in the tech bubble in 1999, but this causes a governance issue and a reputational risk for the exchange because the companies are, many of them are of poor quality, so they're very poorly capitalized. And if you're in the exchange and you see the number of companies doubling in a very short span, and you know the quality is less than ideal, that poses a reputational risk. Peak 2 I identify as being somewhat related to this. It's actually 2 sets of rule revisions, one in April and one in July 2005. The first relates to investing companies. Investing companies are companies who do not have an operating activity, such as conducting a business in the conventional sense. Their main source is simply investing in other companies, and they define as investing companies. The problem with them is that you can have cash shells listed on the exchange where the revenue is essentially zero, close to zero. So you can have cash shells with market caps of less than $1 million. And that's what you see in April. You see a high number of these revisions are relating to restricting cash shells. And in July, you see the implementation of the prospectus directive. And I describe that as having to do with reputation because the exchange justifies their adopting prospectus directive light rules instead of maintaining their old rules on a reputational basis. And I justify this with guidance documents and publications from the exchange. The third peak is not the highest, but it's the most significant. Now, the third peak is in 2007, and that's when the exchange introduced a separate rulebook for nomads. Up until this point, there were a couple nomad rules in listing rules, and there were eligibility criteria. Now, 2007, symbolically, number one rule in the listing rules, you need to have a nomad. Now there's a separate book on nomads. Now nomads need to report as soon as practicable to the exchange any suspected violation. These are big changes. Why? Well, in 2005, at the end of 2005, we saw the biggest scandal on AIM to date, where a company called Langbar essentially conducted fraudulent activity. Investors lost hundreds of millions of pounds, but most importantly, it was publicized. And this was the front page of many leading newspapers in the UK. And I present evidence in the paper where journalists say this is the most significant reputational hit AIM has taken to date. And one journalist even suggests that the scandal may have played a role in revising the rules going forward. So just to step back for one moment, what this shows is that there's the data that I'm presenting, and then there's my interpretation of the data. So a higher bar does not necessarily mean more qualitatively significant rule revisions. I'm simply quantifying the degree of major and minor revisions that I've coded for. I do speak in the paper about the possibility of rule tinkering, which I say could be when a rulemaker wants to engage in lots of revision activity that is not qualitatively highly significant. I don't suggest that this is the case here, or at least I'm hesitant to suggest that, but in some sense you can imagine the higher the bar, if there was some way to have another bar next to these where you could somehow assess the true materiality from a practitioner's perspective or from a regulator's perspective, the difference in those two bars would sort of be the amount of rule tinkering. Now, peak 4 is less important despite being high. It relates primarily to investing companies, and at the time, the rules were precipitated by the highest ever number of sub £1 million issuers, which is a reputational risk and a governance risk for the exchange. Why? Because just like the Langbar scandal, these companies essentially have very little cash. Why are they listed on the exchange? Will they go bust? Essentially, the LSA need to clean up some of these companies. And peak 5 primarily relates to disciplinary rules. So a new disciplinary handbook was produced in 2018. It doubled in length, both by word count and by rule count. And I suggest here that this was because of a case in 2017. This case regarded a nomad, Zai, Z-A-I, and essentially the nomad challenged the exchange's decision to prevent it from having a hearing in public. This went all the way up to the Court of Appeal of England and Wales, and the exchange essentially, I believe, needed to clamp down on sort of reputational risk of nomads being able to take them to court on the procedural rules. It's just that was the fifth peak. And so what I'm trying to show in this peak is I'm trying to examine whether there's evidence for a trigger and response theory of rule evolution. I'm trying to see whether, in fact, rules are evolving episodically, meaning in peaks and troughs, or if rules are evolving in more of a flat line. And I am by no means the first to think of rule evolution in this way. I try to contextualize this in the paper by describing different theories. And so some in the law and economics camp have described sort of Darwinian theories of rule evolution, whereby natural selection you see a small, continual progression of rules. Others, such as Mark Rowe and Una Hathaway, have applied theory of what they call punctuated evolution to rules, suggesting that actually you have a big shock to the system, rules evolve, then you see stasis, so period of relatively consistent relative absence of rules, and then another shock. And what I'm suggesting is that AIM exemplifies this latter trend. I'm just going to quickly through a couple images and then jump straight to questions. This is showing major revisions to the exchange over time. And we're seeing stripped away the minor revisions, that rule revisions are front loaded. So in the first decade of AIM, we see more than 3/4 of rule revisions. Each of those lines are when the rule revision was incorporating a public law source. Now, I have a variable I code for in the data set called public ordering. And essentially, anytime a rule incorporates a legislative source, so imagine a rule copies text explicitly from the prospectus directive, that would be an example of public ordering. And so this shows when rules do that, when rules on AIM have incorporated those public law sources. And the red shows when the exchange voluntarily incorporated these sources. The orange shows when the exchange did not and was forced to. We see that the majority of public ordering is voluntary. Here is interesting because it shows how even when there's low rule revision activity, there is disciplinary activity and enforcements. It also shows that the number of formal enforcements on AIM, meaning formal enforcement procedures initiated by the London Stock Exchange, is quite low. On the right-hand side, you can see it averages 1 to 2 a year. This slide shows how different categories of rules change. So what you see is about 25% of the time, only one category of rule changes. And in my data set, I've classified them into different categories. So we have rules on eligibility, rules on disclosure, rules on corporate governance, investing companies, discipline, nomads, and supervision. And we see that the majority of the time, rules evolve in tandem. And so this chart just simply shows what types of rules evolve when. It shows that some types of rules seem to evolve more than others. For example, corporate governance and disclosure, the green and the yellow, evolve more in the first 10 years of AIM, whereas investing companies, the purple, evolves more in the second 10 years of AIM. 2 final slides. Become more enabling over time. I thought this might be interesting because perhaps the exchange would seek to keep a high number of mandatory rules in order to, oh, I've lost my video, in order to contain control over issuers. The idea being that more mandatory rules prevent, essentially maximize the amount of control the exchange has. That is true. The rules do remain mandatory over time for the most part. And this final slide, do the rules become more discretionary over time? The answer to this is no, they don't. I thought they might have. My hypothesis was because I thought the exchange might seek to create rules that require less ex ante clarity on compliance and more ex post sort of gray, giving the exchange more leeway to determine compliance. We see that surprisingly, the rules actually don't become more discretionary over time, which contradicts the hypothesis I might have had. While I fix my video, try to get that back on, I would love to welcome any questions and hear your comments. Thank you.
Thanks, John. It was me who stopped your video because the audio wasn't perfect. It was okay, but not perfect. So I tried a little bit late whether without video it would be better. But anyway, so the floor is open to questions from anyone. Please. I'm John's supervisor and I'm already commented profusely on this paper, so I confess I don't have much to add. I strongly encourage others to make comments and questions. Geneviève.
John, actually, I have a general question, a quite general question, but I'm interested. It's great you put together this data set. Very, research as it should be done, and to be, really empirical studies, etc. And I was wondering whether you could share with us the challenges you faced when putting together the data set, and so perhaps you could also give us some advice.
Thanks, Sidya. I think it was a real learning process for me, if I'm honest, because I didn't realize that every time you learn a little bit more and you adjust the coding criteria, you now need to go through all of your data again. So I think the first challenge is making sure you have a complete data set. Some archival copies for a couple years are blank in my data set, and I account for this, but that was the first challenge. Second was, I think, the time intensity of the process. So I don't say this explicitly here, but this essentially has taken at least a year, really, to be able to go through the rules and meticulously compile them. And then the third is yes, the experience of constructing the right criteria up front, because every time that gets adjusted, you need to re-go back. And I think if I could restart everything again, or what I've learned, I would workshop my coding criteria before I've then done everything, because again, that's the thing you want to get most right. And sorry, you're on mute.
What do you mean by workshopping?
Oh, I would try to present my criteria at a workshop prior to doing the coding, because now what's happened is I'm somewhat restricted in that what's my research is set in a certain way, and I can make adjustments, but not fundamental adjustments. And I think I now see the value of really exploring early on with others how to divide the data.
If I may ask you a follow-up question, very short one, because of course, what is really difficult is to find how you're going to do the coding, right? And I wonder, because this is not in your paper, were you inspired by previous work, as that you could use as a benchmarks? And in other words, how do you know that your coding is?
Well, I guess LLSV's 98 paper on legal origins and market depth and capital markets, I think inspired me and has sort of set off this field to some degree. But in terms of I was quite familiar with Simon Deacon and John Armour's work on
I was wondering, what about the Cambridge?
Yeah, the Cambridge data set. And that was the more recent inspiration. But for me, I had to tailor it because I'm interested in when rules evolve and why, as opposed to understanding at a more macro level trends in an index fashion. And so I needed to, instead of coding for the rule itself every year, that is still a lot of work for them. But essentially, once you've coded for 1 year, the coding doesn't change until the change. So you might have 10 years of it's just the same. For me, I'm looking at every revision and I'm having to redo that analysis. And so it's a different methods. And I didn't have an example of how to do that. So that took me some time to try and come up with something.
Thank you. I think you should write a research method paper once you're finished, and that would be helpful.
That's a great idea. Thank you.
Tom?
Hey John, I have a quick question, because as you know, we've already spoken about this paper as well. So what I like about the paper, but I'm also still puzzled by, is the spikes in the data, and I think what you describe is it's a representation of the reputational theory, or at least it's in line with the reputational theory. So I suppose I have two questions. The first is, reputational triggers seem to be related to scandals, and scandals seem to be related to tumultuous market times. So would your hypothesis be that in the current period, we're going to see more of these spikes happening or not? And the other question I had related to, in the paper, it's figures, I think 8 and 9, where you unpack the different changes by whether they relate to disclosure, corporate governance, investing companies, and so on. And I just wonder whether you think there's anything specific to the nature of those rules that makes it more likely that they're changed more frequently. So, for example, is the cost to changing the rules lower? Is the rule change more meaningful or less meaningful depending on what category is targeted? So just kind of clarifying questions, I suppose.
Oh, thanks very much. It's really helpful. I hadn't explicitly thought before about whether there might be a connection between scandals and times of crisis. So I'll need to explore that. To directly answer, I actually think, given when I'm in a situation of crisis, I actually think we'll see less peaks over time, and that's because, if I can say this, there were more reputational risks in the first half of AIM's existence because the rules perhaps allowed for that, by which I mean that many of the holes have been plugged, so to speak. And so I think what your comment is making me think is, for example, the COVID crisis may test the rules now and show what are the new holes. But my understanding of why things evolved so much in the first half was because there were a significant number of holes. And so ideally one would see less of those peaks perhaps over time. But this is making me think.
Yeah, can I ask a follow-up question here? Because
yeah.
That seems to, and that, much of the analysis in this paper, but also the point you're making now is kind of contingent on sort of the AIM system, if you will, reaching an equilibrium state with certain players that have invested and built a reputational capital. They have a certain way of doing things and things stabilize. But does that also mean that as a marketplace or as a exchange that AIM creates barriers to entry, that it becomes less dynamic, because that's kind of, I think, what your comment is suggesting.
That's a very good point. So that I'm actually thinking about that question right now because I'm thinking about my policy conclusions, and one of them, if I may tentatively throw it out, is that what AIM is doing is it is moving away from a goal to be a true market for SMEs in favor of higher capitalized issuers that are more stable and more safe. And that's good from an investor protection perspective, perhaps, but that is not good if the regulatory objective is access to capital markets for venture issuers and growth issuers. So I think you're absolutely right. Actually, I've been thinking about that, and the trade-off isn't explicitly framed, but I do think it is an explicit trade-off. Yeah.
I have a question from Professor Getzler.
I go by the name Joshua mostly. I enjoyed your paper. I'm sorry I came in late because I had teaching. I also enjoyed reading Katrin's paper. My comments might go in both directions. You have some interesting observations, Mr. Chan, on race to the bottom. Yes. And maybe you didn't want to put your full gamut of thoughts, because it's a quantitative paper and a methodology paper, about what you think about race to the bottom framework of argument. But my understanding has always been there's a deep puzzle about whether the choice of a forum for trading capital is about favoring the managers or the investors. So the managers may have the whip hand and can decide that we can screw our investors by going into a Delaware and going to some low regulation financial brothel like London. But the investors may lose. But the investors, do they have the focused ability to coordinate and say, no, we're not going to invest, we're going to take our money elsewhere? So do you have thoughts about how race to the bottom mechanisms work? You express skepticism that this is an explanation for AIM, that very high quality regulation, but it has to be flexible. Who are we trying to please? Who are we trying to maximize? Whose interests here? That was my first question. The other question is, can you draw a hard line between soft regulation by the self-regulating private entity and other frameworks of legal control? Is that a hard and fast line? I know about this because we're on the brink of yet another stage in the hard Brexit. And part of the prize seems to be the government is going to give itself a blanket power to rewrite through secondary instruments without parliamentary scrutiny the entire rule book. And I've already seen this in my work on credit rating agencies, that the ESMA injunctions to improve control have been gutted by secondary instruments in this country, which I suspect was written by industry. So we have public choice theory and rent seeking. Is it possible to draw hard lines between what private actors are legislating with some level of public supervision and whether it actually goes the way around? Private actors are supervising public legislation.
Thanks very much, Josh. I'll take the easier question first, which is the first
one.
Yeah, as a relative term. That in 2007, right around the peak of some of these scandals, AIM was criticized to be racing towards the bottom. So that's where some of the language was coming from. Obviously, in the context of securities regulation, there are different perspectives. So some, maybe Roberto Romano would be more in favor of a sort of regulatory competition approach where you compete for listing venues, and that encourages good governance all around the board. The criticism one level that AIM was that in an order really to gain listings, it had lowered its the quality of its regulation and is moving downwards. And part of what was in my mind was, do these data confirm that? And I think in terms of your excellent point about coordination, investor coordination, because AIM has a much higher proportion of retail investors, it is harder to coordinate. And so in terms of whose interests is AIM catering to, I think it would be most likely managerial interests. However, the race to the bottom is halted, I think I'm suggesting by this theory, by some of the reputational concerns of the broader London Stock Exchange group.
Are there secondary pricing, if I can just slip in another question? You don't have to worry about my point about regulation and government, because that's just too amorphous. So let's concentrate on the race to the bottom. I understand that people like to list, companies like to list, cross-list in NASDAQ or in New York or in London, not because they expect to do trade or business there, but it's a kind of a seal of good housekeeping. You get a premium if you register in more than one place because you've cleared regulatory hurdles, and it sends out some message that you're a better company if you're in one of the large centers. Can you measure that? Can you measure the impact of cross-listing? Do AIM investors also cross-list elsewhere? And is there any advantage if you're in AIM to cross-list in other larger exchanges, or the other way around? If you're in New York or London, is there an advantage to cross-list in AIM? How does cross-listing work in your market?
That's a great question. I actually, in the first year of my PhD, I spent some time looking at the data on cross-listing, and it looked to be relatively low compared to the main market and the NASDAQ. I actually need to return to that. I don't know that offhand. I think what that's making me think about is to what degree is there a reputational premium, or to what degree would investors would it lower the cost of capital, essentially? To what degree would cross-listing on AIM lower the cost of capital? And I guess to some degree, that question is all dependent on the value of governance on the exchange itself. And so what would be really interesting is if the more the reputation of AIM declines, the less valuable that cross-system premium is. And so if I were able to show, for example, that, as AIM has cleaned up some of these holes a bit, that cross-listing has increased, that might be an interesting source of data for the paper.
Thank you. I see no other comments. I will just add a couple of points to Joshua's questions, which are, first of all, that AIM is a market for small companies, and the very business proposition there is that it is a low-cost, non-regulated market. And the low cost also comes from the fact that it is not a regulated market. It is an exchange regulated market. And so cross-listing is really for large, fully listed companies. It would be quite, I mean, it would be beyond the size of the average, and possibly also the largest AIM companies to engage in cross-listing. The other thing is that, as John said, it's really a matter of protecting the market's reputation that will prevent the LSE from having rules that are too lax, because you can attract even retail investors for a long time if the standards are sufficiently high. If you create a market where fraud is widespread and people just lose their money, then you can run the business for maybe a few years, but then no one will even take the risk of underwriting, buying shares listed there, and therefore it will be very costly for a small firm to list there, because you have to, you will raise very little money, and therefore it will not be worth it unless, of course, you dilute your holdings, you sell a lot of shares, but then you lose control and you lose cash flow. So it doesn't work as in the long term to set up a market with very, very low standards. I don't see any other question, but it's 4 minutes to 2. And so perhaps it's time to thank our 2 speakers today and to adjourn to next Wednesday for the last workshop. It will be Clara Martins Pereira and Nikita Agarwal who will present their papers. Thank you so much, and see you next week at the latest. Bye.
Thanks a lot.